I thought we were all in this together. Good morning, anyhow.
Good morning.
Okay, so I guess you have a court date too. We're all just hanging around.
We have one at 9 as well.
What? Are you serious? This is the fourth person that says they have a conference, a Zoom conference with the court at 9.
I think a bunch of people do.
Yeah, make it 5.
Wow.
And I'm at 10:30.
Good morning,
So
everyone, and welcome
But
to courtroom C201, the probate courtroom here in Lake County. For many of you, this Zoom experience may be a new one. So we're doing the very best we can to be patient and cooperative with each other. There's a few ground rules I'm going to establish. First of all, this is still a courtroom. So your appearance and your behavior should still be appropriate as if you were standing in the physical courtroom. If you haven't had an opportunity to do so, please rename yourself on your screen. You can do that by hovering over the top right-hand corner of your screen. It'll allow you to rename yourself. If you put your name and also your case number, it's very helpful to me in identifying who you are and also to the clerk so that she can keep proper minutes about who is present here for this court hearing today. I'm going to ask you to please mute yourself. I can see Kit, that's Kit's phone. You're not muted. Please mute yourself until your case is called because background noise and conversation can be very distracting to the court process.
Okay, so
During the call, thank you. During the process, you may look down at the chat bubble in the bottom middle of your screen that will have a number on it if the clerk is trying to reach you, and she can chat with you privately if there's some information she needs to get from you during the court process. So please keep your eye on that chat bubble. At the conclusion of today's hearing, if you're going to be submitting an order to the court, you're going to be doing that by email to this email address. So please write it down. cc201@lakecountyil.gov. And for the purposes of this hearing today only, they'll be sent to the attention of Kathy, K-A-T-H-Y. And if you can please add that to the notes it's very helpful in sorting the different orders that are coming in throughout the day. So again, CC201 this is all one word with no interruptions, Lake, L-A-K-E, County, C-O-U-N-T-Y, IL.gov, today to the attention of Kathy. When your matter is called, I'm going to ask you to please unmute yourself so that you can be heard. I'm also going to ask that when your matter is concluded that you will leave the virtual courtroom. If you'd like to continue watching the proceedings today, you may do so by YouTube, but it's very helpful to us if we can limit the number of people that are in the virtual courtroom and helping to administer the court call. I'm going to make a couple appeals to you. We have an administrative orders that allow you to handle matters remotely in certain circumstances, like opening and closing of uncontested estates, matters that are agreed, or other matters that are uncontested. Please take a look at our administrative orders, AO 20-21, AO 20-28, and AO 20-30, which address all of those issues. If there has ever been a time to be reasonable with your opposing party, your opposing counsel, this is it. Please contact each other in advance of court dates. See if you can make agreements about briefing schedules or hearing dates and submit those by agreement to the cc201@lakecountyil.gov email address, which will help avoid court appearances by this method and make everyone's life much simpler. We know for certain we're not getting this 100% right every day, but we are trying. I'm going to make an appeal to you to also please be kind and patient, keep your sense of humor in the process, and we all here are trying to do the same. Thank you for your attention, and we'll start calling the cases. The estate of Patricia Vin, VYN, 14P822.
Morning, Your Honor. Sarah Barnes on behalf of the respondent, Janice Cherry.
Okay, who's here on this case? Mr. Pasquesi, are you here on this case? You're muted.
Oh, there we go. Yes, good morning, Your Honor.
And Mr. Craddock?
Well, Your Honor, Mr. Craddock, he had sent or actually had filed a letter with the court. I don't know if you saw that. He's been temporarily suspended from practicing law, and that is the only communication that we've received from him, and I don't know whether, I have no indication that anyone else would be appearing today.
Okay.
So Your Honor, Sarah can go over the details, but I was involved in this from the beginning. Two sisters can't stand each other. One's a lawyer with a biggish firm down in Texas. The other one is local. The sister in Texas was the guardian for mom. Mom died shortly after the guardianship was set up. Then there was the decedent's estate. The sister was the executor. The Texas sister was the executor. The other sister refused to cooperate in any way. She had a lawyer named Harold Salfeld throughout the entire proceeding. As a result of her lack of cooperation, everything that was done in the guardianship and decedent's estate was all approved by the court with notice to Harold and his attendance at everything. We wrapped the thing up, I don't know, Sarah can give you the details, a couple of years ago. And then they come back with this petition to reopen. We filed a lengthy motion to dismiss. You gave them time to respond to the motion to dismiss. Then they didn't do anything. They asked for time to replead. You gave them time for that. All those time frames have come and gone, and they've filed nothing and no request for extensions. So the essence is we're asking that you rule on the pleadings as they stand, rule on our motion to dismiss. Alternatively, give us leave to file a motion to dismiss their petition for want of prosecution, which we could file today.
Well, on the court's own motion, I'm going to dismiss it dismiss it for want of prosecution. They're not present today. The motion has not been advanced. The motion to dismiss is granted.
Great.
Okay. So you'll, Ms. Barnes or Mr. Pasquesi, you'll prepare an order. You're going to send it to Kathy's attention today before 3 p.m. at the CC 201 email address.
Your Honor, we also, I will do that. We also have a pending motion for sanctions that was filed consecutively with the motion to dismiss.
Okay.
That was entered and continued until this date as well. We can file a fee petition within, I don't know, 21 days if that's agreeable to Your Honor. Most of the allegations relate to the allegations in the motion to dismiss.
Okay, so if you want to supplement your motion for sanctions with your fee petition, and if you would send courtesy copies of both to me, and we'll set it for, how much time did you need? You said 28 days?
21 days.
21 days. July 16th at 9:00 a.m. Is that enough time?
Yes.
Okay. Thank you.
Okay, thank you, Your Honor.
Thank you.
The estate of Kenneth Curry, 20P169.
Good morning, Your Honor. I am the GAL on the case.
Good morning, Ms. Ayala.
I don't know if anyone is going to be present. It is a pro se matter.
Okay, is Kenneth Curry here? Have you had an opportunity to do an investigation, Ms. Ayala?
I did. I've spoken with the father who is the petitioner on this matter various times. The last time I spoke with him, it is my understanding that Mr. Curry was incarcerated in DuPage County. I tried calling them earlier this week, but I wasn't able to get a hold of him. So I'm not sure if that's still the case. I did do a search at the Duke online to see if he was still an inmate. I did not see his name on there, so I'm not really sure what's happening with that.
Okay.
I would request additional time to complete my investigation.
So when you're referring, because they're both named Kenneth Curry, when you're referring to the person who you believed to be incarcerated, you're talking about the alleged disabled or the?
Yes, the son. Yes, the father's petitioning for the son in this matter.
All right, so what I'm going to do is I'm going to continue it to allow you to complete your investigation, and also requiring the appearance of the petitioning guardian, Kenneth C. Curry. How much time would you be asking?
Can I get 3 weeks, Your Honor? So that would be,
How about July 15th?
that's fine, Your Honor. July 15th.
Would you be willing to prepare that order and submit it?
I will.
Thank you very much. To the attention of Kathy, very helpful to us.
Okay, great. Thank you, Your Honor.
Rafael, I appreciate your help in this matter.
Okay, thank you.
The estate of Joel Thomas Findley, 20P287.
Findley, Your Honor, Kathleen Georgievich on behalf of the petitioner. We were up today for a hearing on plenary guardianship. However, I was just informed earlier this week that unfortunately the respondent did pass away. So he was a decorated war veteran, so it's a great loss. So I would just like time to file, I don't know, do you need me to spread of record his death? We don't have a death certificate yet. So discharge the temporary guardians, it expires today anyway, and then leave to file spread of record his death.
That's perfectly right. I'm very sorry for this loss. And how much time do you need to prepare that?
I think 2 weeks should be fine.
Okay, why don't we set it out to July 15th, but
Perfect.
obviously if you filed it by email in advance of that date, the appearance won't be necessary on July 15th.
Okay.
Okay.
So we'll leave the estate open, discharge the temporary guardians, and then until file on or before July 15th, a motion to spread of record the death.
Death of record, yes. And I assume that it'll be done in advance and I won't see
Yes.
it. Okay.
Yes. Great. Thank you, Judge.
Georgievich, and I'm sorry again for the loss.
I'll pass that on to the family.
Thank you.
Thank you.
The estate of Osiris Oates, 13P7.
That's me, Your Honor. Can you hear me?
Good morning. Is that you? Is it Sheila Jefferson?
Yes, it is.
Okay. So, Ms. Jefferson, it appears that you are asking to reopen a disabled estate.
Yes.
So this estate was initially opened back in 2013.
Yes.
But there were no annual reports filed on the status of the disabled.
The status of him right now?
So one of your obligations as acting as a guardian for a disabled person is to file an annual report with the court establishing what the circumstances are of the disabled person's, you know, residential circumstances, his medical circumstances. There's a form that's supposed to be filed, and that was not filed.
Well, I know I didn't file it, but I filed it when I came in because I thought it was in April, but I guess not. But I did file one and put in with the court, and then you guys changed my court date.
Okay, so I still don't see that it has been filed.
Really?
No. I see that you filed a motion that says that you would like to reopen the estate.
Okay.
There's an actual form that you would need to answer specific questions about the circumstances. Is this a man or a woman?
This is a man.
Mr. Oates?
Yes.
And that still has not been filed. So I'm going to ask you now, what are the circumstances of Mr. Oates? Where is?
Okay, right now, Your Honor, Osiris is in Winnebago, Rochford jail because the hospital sent him to a shelter and he left. Somehow he got to a Walmart out there and he attacked some people and they arrested him. So he been there for the last 2.5 months. I've been trying to reach out to some other organizations that could help me try to get him in the proper place, but because he's been sent from group homes to nursing homes, which I don't feel they can really help him for his needs. And I can't keep him at home, obviously. So with my guardianship, I was going to see if you guys could help me get a state representative to maybe I can get him put in the proper place. Because he done been in about 25 hospitals in the last 3 years.
Okay, so the last report that I see on Mr. Oates was in 2018, and he was in a hospital in Cook County.
Yeah. There's been a whole lot of things, Your Honor, in the last year.
Okay. All right, I'm going to pass this case for a few minutes. I'm going to ask you to stay on the line. Okay. And I'm going to ask you to put yourself back on mute. I'm going to hear some other matters and then I'm going to come back to your case. Okay.
Okay. Thank you.
State of Ivan Rodriguez, 20P120.
Good morning, Judge. Jed Stone on behalf of the petitioner, who is online as Liz's phone. And Anna, if you could unmute yourself.
Okay, so I see somebody with Liz's phone, iPhone. Okay, you're muted. So you need to, if you see the microphone with the red line through it. Okay, still muted. Can you?
I don't know that we need any testimony from Anna.
All right, but Mr. Ackley, so I had this set at 11:30 a.m.
Huh.
Because
so we'll come back at 11:30.
Well, there was going to be initially, it was my understanding that the alleged respondent, Ivan, wanted to appear, and then there was a change in that.
That's correct.
It had been reset to 11:30 at Mr. Ackley's request because to accommodate Mr. Rodriguez's appearance. When Mr. Rodriguez did not want to appear, I don't know if there was any adjustment in the time. So what I can do is I can pass it, Mr. Stone, if you'd like to contact Mr. Ackley, if he's available to appear now, I can recall it.
Thank you, Judge. I'll reach out to him, and if we can, we'll rejoin you. Otherwise, I'll see you at 11:30 with Ms. Schmidt.
Thank you. Just let the clerk know. The estate of Frederick Alexander, 20P144.
Good morning, Your Honor. Anna Zamashvili on behalf of the petitioner.
Good morning.
Good morning, Your Honor. Joshua Schwartz, guardian ad litem.
Good morning.
Your Honor, we had continued this matter over from last week. Basically, we've got a temporary guardian in place, Midwest Care Management, and we have been working with the Office of State Guardian on whether or not to transfer this over to the state guardian. I don't believe we're quite ready for plenary, and I'm sure Mr. Schwartz has plenty to report back regarding his meeting with Mr. Alexander. And then I just have I had filed a new petition as the full 120 days is up actually today. So we filed a new petition to have Midwest Care Management remain on as the temporary guardian, as the state guardian had requested a few estate matters be taken care of before they could take the matter
Good. Yes. So I have no objection to the temporary guardianship be extended, Your Honor. There was a little bit of difficulty getting in touch with Mr. Alexander. He's at a facility, but I was able to have a FaceTime interview. I read him his rights and I went over the petition with him. And then I just recently, the other day, spoke with one of the nurses at the facility. So I had finished my JL report and I thought perhaps my assistant would have sent it in as a courtesy copy, but it appears that did not occur. But my opinion is that a guardianship is necessary for Mr. Alexander, both the state and person. So I don't have an objection to the temporary being extended. I can definitely circulate then my JL report on the issue, and whatever date Your Honor deems appropriate. I know Miss, sorry if Anna, I don't know how to pronounce your last name, so I apologize, needs time with the Office of State Guardian to deal with certain property of Mr. Alexander, so it might take some time. So I don't know if we want perhaps a 30 or 45-day date to come back, and perhaps we can close this issue and enter powers of attorney. Or excuse me, not powers of attorney, letters of office, excuse me.
In Your Honor, specifically the outstanding matters that the state guardian had asked the temporary guardian to take care of is Mr. Alexander has a vehicle, which is basically junk at this point, less than a few $100s valued, we'd say. So in addition to the regular authorities that we would ask for a temporary guardian with acting as surrogate, consent for placement, investigating, collecting assets, etc. In my proposed order, I've included language to either sell the vehicle to the highest offer or junk it, given that it has no value. And then state guardian has also requested that with the minimal funds that Mr. Alexander does have to purchase a Medicaid eligible prepaid funeral. And then lastly, Mr. Alexander's landlord has been pretty much itching to clear out his apartment. It's not expected for Mr. Alexander to return. He's wheelchair bound, and given his health, I don't think it would be a prudent idea to send him back home. So we'd asked for additional authorities to either sell his personal property if it has any value, if not, to transfer the belongings to any family members. He does have a son who we did provide notice to via email, or dispose of the personal property if there's nothing to do. So other than that, it's just all the regular requested powers and authorities.
Mr.
Yes, Your Honor. And no objection to those. Mr. Alexander had suffered a stroke, and the left side of his body is basically, he is going through therapy, or what they consider therapy, at the rehab facility. But he is wheelchair bound. He's unable to toilet himself. He's unable to shower himself without assistance. It is not really feasible for him to reside on his own in any capacity in any near future. So I don't think it's inappropriate for the powers that Miss Anna is requesting to be asserted for the temporary. I have no objection to those. And I think we're just kind of waiting on the OSG to get approved, and this matter can be then resolved.
Okay. All right. So if you, I'm looking at July 22nd or July 29th.
Either of those dates should be good for me.
Either of those work for me, Your Honor.
Is a little more time better? Because we're going to be going on the new petition now, right?
Yes.
Okay. So
that takes us out to August 14th would be the first 60 days. So honestly, any time.
All right. Why don't we say July 29th at 9 o'clock? And then you are going to, and I'm going to ask so that I don't mispronounce your name, if you'd say it for me.
And Zamashvili.
Damashvili.
Yes.
Okay. Ms. Damashvili, if you would, you're going to be preparing that order.
Yes, and I can send that in a couple minutes.
Please attention before 3 p.m.
Sounds good. Thank you very much, Your Honor.
Yes. And Your Honor, before we go, do you want me to circulate my jail report now, or do you rather be closer to the date so it hits the file then?
You know what? Why don't you wait, because also there may be additional information, and that way it'll just all be current before that next date.
Certainly.
Okay. Thank you.
Thank you, Judge.
Your Honor.
Thank you.
Do you have some class? Are there any attorney matters that have not been called?
Good morning, Your Honor.
Good morning.
Michael Blattner appearing on 2 different cases. Did you say attorney matters?
Yes.
And that's, I'm here on the estate of Samantha Chrisman, a disabled person, 97P 777.
We're getting the files, just a minute.
Sure.
There's one. Okay, Samantha Chrisman, 97P 777.
And Michael Blattner appearing on behalf of the Chicago Trust Company, who's trustee of the Samantha Chrisman Special Needs Trust. There is quite a bit happening here, some customary, such as presentation of the 11th current account and a petition for approval of trustees' fees. Also,
I did
related to
courtesy copies, thank you. I just have a question. On the 11th current account on page 13, it seems the habit of Chicago Trust to leave blank the cash on hand at beginning and cash on hand at end.
Yes, that is a common question. Because they have mutual funds that are like cash funds, they feel it's their protocol never to have cash on hand because it can be earning a small amount of interest or earning potential if they have it in one of their other mutual fund systems. So yes, that is a very common question, Your Honor.
Okay.
Never hold cash for even a day because they will make money on every penny invested in their mutual funds.
I see. Okay, thank you for helping me to understand that. Otherwise, I do approve the accounting.
Thank you.
I know that there was this issue regarding the real estate.
Yes, and that is, you know, petition for direction and brainstorming the situation with the guardian of the estate and trustee. Basically, we have the prior guardian of the person who's the sibling of the disabled adult staying in the estate-owned home, even though Samantha is now in a care facility and doing reasonably well. We have talked to her about, I'm speaking of Heather, I lost her last name, the guardian of the person, and she has been real estate or an apartment to move into, and that has yet to happen. What I am proposing in my proposed order that I'll tender to Your Honor shortly is that if she's not exited the property by July 1st, the guardian of the estate and trustees granted leave of court to file a petition for rule to show cause why she should not be held in contempt of court, just to keep things moving. While Samantha is doing fine in her care facility at this point, the real estate's depreciating and falling apart as it has for many years.
So I am very concerned about that real estate and that those funds, and instead of the assets of the estate being used to maintain a home that is of no benefit to our disabled person, that those funds be, you know, put to use for the benefit, for her benefit. But I'm just not certain about that course because I don't know that the court has jurisdiction over, I mean, there's no court, or to have a petition for rule to show cause, there would have to be a court order obligating that person and then saying that they had violated the court's order.
Right, and in my proposed order today, as this has been going on for 90, 120 days, the residents of the property know they've been forced to leave. We've given them 30-day notices twice, and they just haven't moved out. And I understand their situation. I'm just looking because it has been 90 plus days, I'm brainstorming what can we do to get this real estate on the market and get it back into Samantha's estate.
Well, I certainly can vest in the guardian the authority to have that property vacated, take whatever steps are necessary, and to prepare the property for sale. I just don't know that I can anticipate a petition for rule to show cause. There has to be an order against a certain party and they have to be defying it. So I can't anticipate down the road. But
No, I do understand. And I'm brainstorming here also. Right now I have an order to vacate and leave to the guardian of the estate to file a rule to show cause. I can definitely strike the second portion of it and we can.
What I can do today is authorize the guardian to take steps necessary and appropriate to have the property vacated and to prepare the property for sale. But what those steps are, you're going to have to take those.
So a rule to show cause we won't have that part of the order, but that may be a step the guardian of the estate will take. That
may be, but
okay.
At this point, I can't anticipate that and say that that's what will happen or that the court would authorize that because I don't.
Sure, that makes sense.
Too premature. Okay, so I'm going to approve the accounting. I'm going to approve the annual report. I'll authorize the guardian to prepare the to make the property take what steps are necessary to have the property vacated by any non-owner and non-tenant and to prepare the property for sale.
And thank you, Your Honor. There was also an attorney fee petition presented this morning.
Yes, and I will also approve the attorney fee petition.
Thank you very much.
And then that order you are going to submit to the email address that I gave previously to the attention of Kathy with a K.
Yes.
Okay. All right.
Great.
We also have the estate of Thomas Amber 09P150.
Yes.
This is
Michael Blatt. Good morning again, Your Honor. Michael Blattner appearing on behalf of Peter Amber, who's the guardian of the person and estate and trustee of the Thomas Amber Special Needs Trust. Thomas is in a care facility in Waukegan. He's doing reasonably well, and there aren't any exciting aspects of this. The annual report was filed. We're tendering the annual accounting, and everything has been.
I did receive your courtesy copies. I've had an opportunity to review and I will approve the annual accounting and also the annual report. I did not see a fee petition in regard to this file though. I didn't receive one anyway.
And I may be confusing that with the other case. A fee petition was filed and if not, I will see what happened there. And we can set it another day.
Yeah, I wasn't in the courtesies. I don't see it in the court file, but.
Okay. And that may be an incorrect provision in my draft order. So I apologize for that.
Okay.
And we're setting a date for the next current account. And
1 year.
Yep.
And it would be a Monday, Tuesday, or Thursday.
I will confirm that is the date selected before we send over the proposed order.
Okay, terrific. Thank you.
Thank you.
Oh, I see Mr. Ackley is here. On Rodriguez, right? Oh, on the. Okay. All right, so I'm going to first recall Ivan Rodriguez. Good morning, Mr. Ackley. Mr. Stone is back again. And
good morning, and Ms. Shrimp is also present under the name Liz's phone.
Thank you.
Judge, I apologize. I had hit Monday, not today's.
Well, no reason to apologize. And there was some confusion about the time because when Mr. Rodriguez was going to appear, we were going to maybe be set at 11:30.
Correct.
And I did receive your communication that he has now expressed a desire not to appear.
Correct.
And I have had an opportunity to receive and review your guardian report, in which you are recommending the appointment of the guardian of the disabled person in Anna Schimpf, correct?
Correct, Judge.
All right, is there anything else that anyone wants to say?
No, Judge, I have prepared or will shortly prepare an order appointing plenary guardian for a disabled adult, a oath of and no surety bond for the guardian, and an acceptance of the office of guardian of the person of a disabled adult to be executed by Ms. Shrimp. And are there any other documents that I need to provide the court?
No, I'm going to make some findings. So on the verified petition of Anna Schimpf for adjudication of disability and the appointment of guardian of the person of the estate of Ivan Rodriguez, the court finds that the petitioner is present, has filed a verified petition for 18, resident of the United States, is of sound mind and has not been convicted of a felony. Is that correct, Ms. Schimpf? Yes, okay. And the respondent is not present, his appearance being waived by the court. He specifically expressed a desire not to be present, although accommodations had been made for him to appear by FaceTime. The respondent having been served with the summons and notice of rights, and the nearest relatives having been given notice, no powers of attorney existing or agents having come forward, the guardian ad litem having been appointed and having done a very thorough report to the court. Also, the court having had an opportunity to review the doctor's report. It's been established by clear and convincing evidence that respondent is in fact a disabled person pursuant to the statute. And the appointment of Anna Elizabeth Schimpf is as guardian is necessary and appropriate for the person of Ivan Rodriguez. Mr. Stone, you have already indicated that you are going to prepare and include those summary of those findings in the appointment of the plenary guardianship order. You are also going to prepare.
Judge, if I may, I prepared the order notifying the state police the statement of the to the respondent to discharge or modify the guardianship, and also prepared an order for compensation to the GAL. So
thank you, Mr. Ackley, for doing that.
The precise things I was going to say next. So thank you, Mr. Ackley.
And then do I send that to CC201 at lakecountyil.gov?
.gov. And for today's hearings, it's sent to the attention of Kathy with a K.
Okay. I will take care of that as soon as this is concluded.
Okay. I think we are concluded unless there's anything else that anyone needs to bring to my attention.
No, thank you, Judge. Thank you, Mr. Ackley.
Mr. Stone, thank you. Anna, thank you. And Judge, appreciate it. Thank you.
Thank you very much.
Anna, call me.
Mr. Okay. Mr. Ackley, do you have another case?
You, Judge. That is on Alessa and Nikolai Weber, 18P 500 and 501.
And Ms. June Peterson Gleason is also present on both those matters.
Yes. And I don't know if Amal is on or not. The respondent's attorney. Is he on, June?
I haven't seen him. He's from Lois Kalinsky's office.
So should we wait if it was this set at?
It was for status of attorney, Judge. And I believe Mr. I can't pronounce his last name, but Amal had filed his appearance, and I guess we just need a new date.
we were hoping to get a pretrial date, Your Honor.
Okay. How soon in time do you think?
The parties they resumed the visits at the Family Visitation Center. Well, just very recently after the COVID-19, it was closed for a period of time. So I was thinking maybe, I don't know, a month or so before we did a pretrial.
Yeah, to see how that's going.
Yeah.
Okay. How about July 14th?
Judge, can we pick another date up? My daughter is due to deliver that day.
Oh my goodness. Well, we're not going to interfere with that. Do you want to go sooner or later or?
Earlier if possible.
Okay. How about July 9th?
9th is fine by me.
That's fine, Your Honor.
You want to do 1:30 or 10:30?
Either is fine.
Either, Judge.
Let's say 10:30.
Okay.
And who will prepare the order?
I can do it, Your Honor.
And then if you would submit that to Kathy's attention, that would be great.
I will do that, Judge.
Thank you so much.
Thank you, Your Honor.
Happy 4th of July.
Oh, you too.
Take care.
Mr. Hatterline, what case are you on?
This is Judge, the estate of Lawrence Lowry and the temporary guardian, who's also the petitioner, is on line with us, Brian Lowry.
So I don't have the file right now, but my recollection was that Mr. Lowry had contacted the court about a continuance, and I noted that you were on the case.
I was able very late last night to file my GAL report. The upshot is I am recommending plenary guardianship. Obviously, Your Honor hasn't had courtesy copies or the opportunity to read it, but he's being discharged on the 23rd, which is a week, to from Shirley Ryan to the petitioner, to the petitioner's home. I find it to be an appropriate placement, but I will certainly wait for Your Honor to absorb the 6 or 7 pages that I filed late last night to, determine whether or not this is an appropriate plenary guardianship.
And Mr. Lowry, you were, I believe, asking for a continuance.
I was hopeful that he'd recover to the point where he wouldn't need guardianship. Unfortunately, the doctors at Shirley Ryan don't think that's going to be the case.
So, do you have the Lowry file? Lawrence Lowry. Okay, so what I would like to do is just set it over for hearing. The temporary guardianship will continue, and I'll set it over for hearing on the plenary guardianship after I've had an opportunity to receive and review the guardian's report. And is there a doctor's report also?
Yes, Judge, I did file that. I filed it as confidential under Odyssey, but it looks like it may have been public. I just thought I'm just saying that for your clerk's benefit. But yes, I did. There was a earlier doctor's report, and then we have one from this week, from yesterday. So it's very current and very good doctor from Shirley Ryan. So there's a very current report that supports the entry of a guardianship order for plenary guardianship.
All right, so I'm just going to continue it for the hearing on the plenary guardianship after I have all of that information. But I am glad, Mr. Lowry, to hear that your father is improving anyway, even if the guardianship still continues to be a necessity. Okay, so looking at maybe July 22nd.
Yes, Judge, same time, 9 o'clock.
Yes.
And Judge, should I preemptively send the orders or should we wait till you rule? Should I say, I shouldn't send those today, right? Because you haven't really.
Yes, no, you can wait until, but I've actually already started to prepare an order here in regard to this continuance. So I'm gonna keep the current temporary letters of office in effect till the next hearing date. And on the next hearing date, when I've got all of the evidence, have a hearing and, you know, either I'll dismiss the guardianship or I will enter a plenary guardianship order, which be a more long-term order, okay?
Very good. So 9 o'clock on the 22nd of July, Judge.
Correct.
Thank you.
All right, thank you.
Thank you very much.
This is the estate of Forrest Cantrell, 20 Pete 15.
Good morning, Your Honor. Danielle Cantrell, plenary guardian.
Good morning. Is there anyone
Judge
else?
Jason Rick present, behalf of Pearl Zhao.
Okay, good morning.
Good morning, Pearl. Your Honor, this is Pearl Zhao.
Good morning. Okay, so I reviewed the file yesterday. I know that there is a current plenary guardianship in effect, and I couldn't see any pleadings that are pending since that time.
Yes, I filed an amended motion to restrict the visitation by the interested party on March 3rd, and that is what we are going to discuss today. The guardian ad litem, Patricia Hogan, was in contact with myself and Mr. Mercure last night. She was not planning to attend today, but did provide some information and guidance from the facility where my dad lives about the kind of a guardianship plan once the COVID restrictions are lifted. Excuse me, I'm sorry, a visitation plan.
Okay, and
That's correct about Ms. Hogan not attending today, but she did reach out to us.
okay, and so I'm not sure what that means exactly.
So essentially, we're having an issue with Pearl. Prior to COVID, she was constantly coming to the facility late.
I'm going to stop you because we're not having a hearing right now. So I don't want you to make any statements that are accusatory. That I'm just trying to find out what we're doing today. So Hogan has made some recommendations. Is that right?
Correct, regarding visitation.
Okay. And so do you accept the recommendations that Ms. Hogan has made?
I do. However, there's an outstanding issue regarding phone contact.
Okay, so let's just hold you there for a minute. Mr. Mercure, you're also in receipt of the recommendations that Ms. Hogan has made?
I am, Your Honor.
And is your client accept those recommendations?
Reluctantly, but yes.
Okay, so so that piece of it we're in agreement about.
Yes.
And then Ms. Cantrell, you have something else you want to say about phone contact?
Yes, there was a previous order dated March 4th, the same day that the plenary guardianship was granted, and it had to do with phone contact of my father, where Pearl, according to that order, was allowed to call once per day around 1 p.m. And that was again based on Ms. Hogan's contact with the facility and some of the nursing staff there, that would be a good time of day. And, you know, the caveat was that, you know, Pearl wouldn't be repeatedly calling it at night, which is not a good time for my dad, given his.
Again.
Okay.
What I'd like to do is look at the court order. Okay?
Yes, ma'am.
So not your interpretation of it, but just what the court order says. So this is the order from March 4th, is that right?
Correct, and it's a handwritten order.
Okay, so let me take a look at it.
Your Honor.
No, please, Ms. Zhou, let me read the order, okay? All right, so at paragraph 5 on page 2 of the order, it says, Pearl shall be allowed telephone contact with Forrest once daily. During said phone call, Pearl shall not discuss this litigation or Forrest's removal. And then at paragraph 6, it says, Danielle shall have Pearl's phone number removed as a blacked out number from Forrest's phone. Number 7, said phone calls shall take place between looks like
PM and 1:30. That's my chicken scratch. Sorry about that.
that's okay. Is it 10 p.m.?
1
No,
p.m.
it's 1 p.m.
1 p.m. and 1:30 p.m. Okay. And then Danielle shall communicate with the caregiver to assist in the phone call. Okay, so let me ask you this next control. Are you asking to change this order?
Yes, because we're having Pearl calling my dad multiple times a day from different numbers, which is not in the spirit of this language here.
Okay, so you're not asking, you're asking that this order be complied with, that it be followed, not that it be changed.
Well, actually, based on emails that Ms. Hogan sent us last night, she had communicated with Mara Wendt, who's the head nurse at the facility. Mara indicated that Pearl is a trigger for my dad, and so I'd really just like to limit the contact to in-person visits, at the agreed upon schedule.
So so if there's something you want to change in the order, then you would need to file a motion so that the other side has an opportunity to respond to it. And if you want to present testimony or evidence about the circumstances, what I can't allow is for you to testify as to what other people are saying or doing. If it's not something that's in your personal observation, but you certainly would be free to bring in witnesses. Mr. McCure, are you in agreement with the current order staying in full force and effect in terms of the phone calls?
Judge, I am, but my understanding is that Pearl's phone still has not been unblocked from when she calls Forrest. In fact, the only way Pearl's having contact with Forrest is when he calls her, because her phone's blocked, which is in violation of the order that you just read to us of March 4th.
So I'm going to say this. First of all, we're going to detail what the specific agreements are in regard to the visiting time today that the parties have both accepted Ms. Hogan's recommendations. And in regard to this phone situation, I have just read out loud what the order says. I don't see a motion, that nothing has been filed that I can see in this court file since that order was entered to modify that order. But that means that both you, Ms. Control, and you, Ms. Zhou, are responsible to comply with this order strictly. If either of you fail to do that, you could be subject to a petition for rule to show cause, which would be a request for me to hold you in contempt of court. So that applies to both. That means that you, Ms. Control, are responsible to make sure that that phone isn't blocked, that that he's available, it's fully complied with. That also means, Ms. Zhou, that you are responsible to comply with that order in terms of when those calls are made. So everybody has to comply with it. If somebody wants to change that order, then you would file a motion and you would say, these are the facts and this is what I'm asking for, so that the other side has an opportunity to respond to the motion. And then if you can't reach an agreement, then I would have a hearing. And at the hearing, you could present testimony or evidence that's within your personal knowledge, or you can call other witnesses to testify. And then I can make a determination of whether or not that order should be changed. Okay. But I will say this, it seems as though, I mean, I remember this case well, and I remember, the very high emotions on both sides. And it seems as though there have been some bumps in the road, but at least there has been some progress and agreement with Ms. Hogan's assistance. I'm hoping that we can continue to reach agreements in that way, because when I think about the most important person in this litigation, it's Forrest. And I can only imagine the difficulty it causes for him to have the people that he cares most about in conflict with each other. And I'm sure that puts a terrible burden on him. So to the extent that we can relieve him of that anxiety, we certainly want to continue to do that.
That makes sense, Your Honor. I just would request, I've never received confirmation of the actual phone number that Pearl may be calling from, and that's part of the issue. I do need that from Mr. Mercure, just so I can make sure that that number is unblocked. There's a lot of spam calls, and if it's a number I don't recognize or know that's associated with Miss Zhao, it makes it more difficult. So, I originally unblocked the numbers, but when I saw multiple calls and with riots in the area and with COVID, there's been a number of people who've died at my father's facility. We can't have him wandering outside his room, which he already has a tendency to do. So that's part of this, is just his safety and trying to make sure he stays in his room so he doesn't get ill or endangered.
All right.
Your Honor.
Mr. Mercure, I'm sure that you're going to provide that phone number, or if there is more than one, what the phone number she would possibly be calling from, right?
Judge, my plan would be to email the phone number or numbers to Ms. Cantrell. I can do that today.
Okay.
Yes, that's fine. As soon as I get those, I will unblock any that are blocked.
All right. So, Mr. Mercure, are you going to prepare the order memorializing the agreement of the recommendations that Ms. Hogan made?
Your Honor, I would like to do that, given that I'm the movant, and I would be happily share that with Mr. Mercure before providing it to the court.
All right. So if you would prepare that, Ms. Cantrell, and if you would send it to Mr. Mercure
yes,
for review. And then if you would send it to the email address I'd given previously. Did you get that?
Yes, I did.
Okay. And you're going to send it to Kathy, Kathy, before 3 p.m. today.
Yes, Your Honor.
Okay. All right.
Your Honor.
Mr. Mercure, your client I know is eager to tell me something. I don't know if you want to chat with her privately or if you want her to say what it is she wants.
I would like you to hear, Your Honor.
Ms. Zhao, I'll just tell you this.
Judge,
I've stopped.
I spoke to her last. I spoke to her last night. She wants to say something to you. Thank you for the opportunity to chat. But
what it is you want to tell me, Ms. Zhao, but I will tell you, I'm not going to hear from Ms. Control into anything other than my understanding is there's an agreement in regard to the visitation. And I am telling you both that the current order regarding phone calls is still in full force and effect. So you need to comply with it 100%, as does Ms. Control. Other than that, if there's something that you want to change, this applies to both of you also. You need to file a motion, and your attorney would assist you with this, stating what it is you want to change specifically and what the facts are that support that change. But there's nothing pending before me right now. So I'm delighted about the agreement that's been reached. I'm glad we had an opportunity to clarify the current order in regard to phone calls. But other than that, I don't know what it is that you want to tell me.
Pearl, let's talk separately.
Okay.
Okay.
I just
you and I can discuss this
I
privately.
don't have anything else to say. Just say that it's in action that you show. I'm concerned with his health and his well-being, and his desire to meet me, and we haven't been able to see each other for a long time. And
so you are free to file a motion, just as Ms. Control is, but the other side has an opportunity to respond to it before I have a hearing and make any decision on it. So
yeah, I just hope.
I'm going to ask this: is there a need for an additional court date? Because at this time, I don't see any matters that are pending. So it would be off call unless somebody files a motion for modification or for some other purpose. So I'd like that to be in order.
Can I ask you a question?
What's the question?
What happens if Dan wants to go to visit his family and he wants me to accompany him? What happens? Do I have to contact Miss Danielle for that permission first, or who
Pearl,
is going to do that?
Pearl, you contact me. We'll talk about that separately. The judge can't give advice on that.
Okay. Because I have no way of contacting.
So the order is going to memorialize the specific agreement in regard to the visitation. it's going to take the matter off call. There's no other motions pending before the court, okay?
Correct. That's correct.
Regarding the phone numbers, you can address it in there, but the phone number should be shared. That shouldn't be in the court order. You can do that separately.
Okay, that's
I
fine.
would just suggest we put in the court order that they're going to be communicated to each other, and I'll email those to Ms. Cantrell.
Thank you very much.
Thank you, Your Honor. Thank you.
Judge, thanks for your time.
Take care.
Pearl, I'll
Thank
call
you.
you.
Thank you, Your Honor.
The estate of Hudlin, Nathaniel Hudlin. Good morning.
Good morning.
And you are Nancy?
I am Nancy.
And you are, good morning. Is that Nathaniel?
That's Nathaniel.
Good morning, Nathaniel. How are you?
Good.
Nice to see you. And who else is there with you?
This is Caleb.
Good morning. You might water.
I'm sorry, what did you say, Caleb?
I said good morning.
Good morning. I'm adding some information to the doctor's report, putting the correct name in. And so today we are here for hearing on a plenary appointment of a guardian. And Nancy, your relationship to Nathaniel is?
I'm his mother.
All right, so Nathaniel, this morning we are here because your mother is asking me to enter a court order allowing her to, you just moved on my screen, to be your guardian. So to make decisions for you in regard to your person, your residence, your medical issues, and those kinds of things. Do you understand that? Yes? Okay. And are you in agreement with that request, or do you have an objection to that request? You're in agreement with that request? Yes? Yes? Okay. So you have a right to have a hearing in that regard, but if you are agreeing to that, then I'm going to go ahead and consider the rest of the information that's been presented to me. Is that what you'd like me to do? Yes? Or no? Yes? Okay. All right, so I've had an opportunity to review the verified petition of Nancy Hedlum for adjudication of a disability, an appointment of the guardian of the person of Nathaniel Hedlum, and the court finds as follows. The petitioner is present, Nancy, and I'm going to ask you to raise your right hand, Nancy. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. And you are over 18 years old?
Yes.
Resident of the United States?
Yes.
You haven't been adjudicated disabled?
No.
And you haven't been convicted of a felony, is that right?
No, I have not been convicted of a felony.
Thank you. And the respondent Nathaniel is also present and has been served with a summons and notice of rights, and the nearest relatives having been given notice and no objection having been made, no powers of attorney existing. The court's going to find that a guardian ad litem's appointment is not necessary in this case for the protection of the alleged disabled, and further find that upon review of the doctor's report, the court's observation of the respondent in open court, the testimony of the petitioner by her petition, and also in open court, it's been established by clear and convincing evidence that the respondent is in fact a disabled person pursuant to the definition of the statute, and that the appointment of a guardian is necessary and appropriate for his person. So Nancy, had you already executed a oath of office, but I just want to review it with you. You understand that you have the duty to annually report about the health and welfare of Nathaniel to the court. Do you understand that? There's
yes.
a form that's available at the, are you familiar with the form?
Yep.
Okay. So you need to file that annually, otherwise you're going to get a notice from the court reminding you to file it, and a citation will issue against you. So if you can avoid that by filing it annually.
Okay.
You also have a responsibility for the health and welfare of Nathaniel. If there are any changes in his address, you need to report those to the court within 30 days.
Okay.
And there is also a training program that you are required to take, and we'll send you, along with these other documents, information about taking that course and then filing the proof that you've done. Have you done it already?
I've done it.
Okay, so you're just going to file that proof with the court. You have
Sure.
to do it, but if you've already done it, that's terrific. You'll file that, and then that issue will be resolved.
Okay.
I'm going to prepare these court orders, and the letters of office will issue to you. They will be plenary. They will remain in effect until, Nathaniel, you always have the right and authority. You're going to get a notice about this also, to come into court and ask that the guardianship be modified or terminated. And that's a right that you always have. Okay. All right. So nice to see you all. And
I just have one question. Sorry. I did apply to be the guardian of his estate also. So does that?
Yeah. And so what assets of the estate are there?
He has essentially maybe $900 to $1,000 in his bank account. There is no other assets.
Okay. So you have to file an annual accounting if you're the guardian of the estate. And,
Okay.
is that what you're asking to do?
Yeah. So I guess I didn't know I had to file something additional. So you need an accounting of the estate in order to grant that?
You also need to file an oath and bond. You're actually supposed to post a surety. If the assets are less than $1,000, I'll waive that, but there's an oath and bond that relates to managing the assets of the estate. And you do have the additional responsibility of filing an annual accounting in addition to the annual report.
Okay.
Okay. All right. Okay. Have a nice day.
Thank you.
You too.
The estate of Idella Davis Phipps.
Can you hear me?
Good morning.
Good morning. Can you hear me?
I can hear you.
Okay, excellent.
And your name is?
Kimberly Davis.
And Kimberly, you are the petitioner for guardianship of Idella Davis Phipps?
Yes, that's correct.
And you are Idella's mother?
I'm her mother, yes.
All right, I'm just taking a minute. I'm just seeing the doctor's report for the first time.
Okay.
Idella is a man?
Yes?
Oh, is a man? Idella?
Oh, no, Idella. This is Idella.
Oh, hi.
I don't know if you can see her.
She's
a woman. She's a young lady.
I'm just curious because the doctor's report consistently refers to her as him.
I don't know. Maybe they're just using the sir of masculine. I don't know why they did that.
Okay, so good morning, Idella. If you could let me see Idella.
Okay. Wait, don't go anywhere. I can follow her to her bedroom. Idella, we're doing the conference call, so you have to come sit with me. Maybe we're gonna go on the front porch. Perhaps she'll stay put.
Good morning, Idella. How are you? Nice to see you. I love that color. You have. Beautiful. My name is Judge Rochford, and I'm here today because your mother, I love that kiss she gave you. Because Your mother's asking to be your guardian and to make decisions about you physically and your medical care and where you live. And I just wanted to know if you're in agreement with that.
Okay, well, she's nonverbal. She's nonverbal autistic, 21.
Thank you. I appreciate that. I just wanted to make sure that I said those words and I had an opportunity to observe her myself, but I can see she is nonverbal. Thank you. And
You're welcome.
I have had an opportunity to review your verified petition, and you're asking for adjudication of disability and appointment of the guardianship of the person of Idella. And I've had an opportunity to review the file and hear the evidence. And I'm finding as follows, that the petitioner is present. You are over 18, resident of the United States. You're of sound mind, haven't been convicted of a felony. Is that all correct, Kimberly?
That is correct.
All right. And I've also had the opportunity to speak to and observe now the respondent. And she's served with a summons and been given notice of her rights. Nearest relatives have been given notice. There's no powers of attorney in existence. I'm going to make a finding that a guardian item is not necessary to be appointed in this case for the protection of Idella. And upon the review of the doctor's report, the testimony of the petitioner, and my communications and observations of the respondent in open court, I'm going to make a finding that it's been established by clear and convincing evidence that the respondent is a disabled person by the definition of the statute, and the appointment of the guardian is necessary and appropriate, and that you, in fact, are the necessary and appropriate person, Kimberly, to be that guardian. I'm going to prepare some paperwork. And you are also going to be responsible to take a class and file an annual report. Did I lose you, Kimberly?
Yes,
okay.
I understand.
I'm going to send you the information about how you do that, and then you're going to file that with the clerk of the court, and then you're going to file the annual report next year and every year thereafter, just so that we know that Idella continues to be doing well and in good hands. All right?
Okay, thank you so very much. I have a question. I don't know if I should ask you this, but what do I need to do if something happened to me? Can I file some type of a petition in court to have like a second guardian or something like that if something were to happen to me?
Yes, you can. You can file a petition asking to either have a standby guardian, somebody who would step in if you couldn't act, or you could file a petition to have a co-guardian, somebody who would act with you currently and then would remain in authority if something were to happen to you, or you would remain in authority if something were to happen to them. But you would need to file that petition, with the court.
Okay, that would be something separate from my guardianship, right?
So it would be the same guardianship, but there could be a person who acts with you as a there's two different things. One is a co-guardian. So you two would act together right now, and if one of you were to be unable to act, then the other one would act. The other possibility is a standby guardian, somebody who would be waiting for something to happen. And if something were to happen to you, then they would step in and act. So they don't have the power now. They're two different things, but they both have the effect of creating a safety net so that Idella would never be without guardianship.
Okay, I understand.
But today, the petition that's currently pending before the court is for you to be appointed, and that's what I'm entering this order. But if you want to address those down the road, you can, okay?
Okay, thank you so much, Your Honor.
Thank you, so nice to meet you.
You too, you as well, have a wonderful day. Come on, Idella. Read that, where'd you get our papers? Come on.
And the estate of Julia Goldstein.
Come on, Idella.
Good morning, Your Honor. I'm Adam Goldstein. I'm with my wife, Susie Goldstein, on behalf of Julia. Okay.
Good morning.
Julia, come here. We're bringing Julia into the room right now.
Here we go. Here we go.
You say good morning.
Good morning.
Are you Julia?
Say your name.
What's your name?
My name is Elizabeth Rochford.
Listening. Good morning.
Can you see me? I can see you. You look beautiful this morning.
Good morning.
Good morning. Julia, we are here today because your parents are asking to be your guardians, to continue to make decisions for you about your person and your health. And do you think that's a good idea? Are you in agreement with that request? They're asking to continue to, do you live there with your parents?
Tell her what to say.
Don't tell us anything. Kramer.
She does live with us. I don't know if she quite gets it.
Yeah, no, I understand. I understand. It's a little overwhelming, but it sure is nice to see you today, Julia. You're a beautiful young lady.
Thank you.
Yes. So I have had an opportunity to review the verified petition of both Susan and Adam Goldstein.
Wait, excuse me, Judge. Do you need Julia still? Or
I don't.
Okay. Thank you.
I have some fun, Julia.
Go ahead. Okay. Thank you.
Delightful. So I've had an opportunity to review your petition and requesting that you be adjudicated as guardians of the person for Julia. And I'm going to make some findings. First of all, I'm going to ask you both to raise your right hands. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Hand up. You're both over 18 and residents of the United States. You haven't been adjudicated disabled and not convicted of a felony. Is that correct?
Yes.
Correct.
And I've had the delightful experience of meeting Julia this morning and had an opportunity to talk with her and observe her. And she's been served with a summons, and closest relatives have been given notice. And I'm going to make a finding that no guardian ad litem is necessary to be appointed for her protection. So upon review of the doctor's report, testimony of the petitioners, my communications and observations of Julia in open court, I'm going to make a finding that it's been established by clear and convincing evidence that Julia is a disabled person pursuant to the definition of statute, and the appointment of the co-guardians is necessary and appropriate for her person. I'm going to prepare some court orders in that regard, and letters of office are going to be sent to you. You know, by signing your oath of office that you're responsible to file an annual report with the court. As long as you file it in June of next year and June every year thereafter, just answering it's a very specific form that I don't know if you have it yet, but it's available on the clerk's website. It's called report. It's called, it's not called report, it's called annual report. And you just answer the questions and submit it. If you forget to submit it, you're going to get a notice from the court. It's called a citation saying that you have to submit it. If you failed to continue to fail to submit it, then the guardianship would be terminated, but I know that won't be the case. Also, if Julia moves, you need to notify the court within 30 days. You're also responsible to take a course. You can do it online and then just submit proof that you've taken that. You have a year before the annual date to accomplish that, and I'll send you the information about taking that course also. Okay?
Thank you.
Questions for me?
I don't think so. Do you have any questions?
So do we, after all this is said and done, we're going to be getting some papers in the mail then?
Yes.
Because what we need is for when we go for to apply for Social Security, they need those papers.
Yes. So yes. So you're going to get, they're called letters of office, and they're going to have a certified stamp on them, and that's what they're going to want to see. You're going to get a series of papers, but the document that's called letters of office, that's the really powerful paper.
Okay.
You the authority as co-guardians to do what you need to do for her protection and health and welfare.
Okay.
It's going to come to you by mail. And if you need additional copies, the clerks here are fantastic and they're going to get it to you very quickly. You'll get it within the next few days. But if you need more of those, you can contact the clerk's office and you can get additional certified copies as you need, or sometimes they want them to be current, like down the road, they want them to be more current. You just contact the clerk's office. There's, I think, a small fee for certified copies, but they'll be very efficient in getting them to you.
Okay, and so is there like a letter or something that, or I mean, I know you're sending a letter, but that we need to show that we're her guardians, like to school, or is that part of that?
So this, again, this letters of office, that's what it's called. And it's not really like a letter, but it's a court document and it's titled letters of office. And that's what anybody who needs to know that you have the power, that's what they're going to be looking for.
Okay, thank you.
So nice to meet you, and especially lovely Julia. I wish you well and have a nice day.
Thank you.
Okay, I'm recalling Osiris Oates.
Yes.
Okay, so Ms. Jefferson, I am going to reopen the estate.
Thank you.
Be appointed as the guardian of the person of Mr. Oates. I am going to require you, though, to, there's an oath of office that you have to sign. You have to fill out and initial each of the paragraphs and then sign it, and it has to be filed with the clerk of the court.
Okay.
And in this document, it explains what your responsibilities are. And one of them, the very first one, is an obligation to file an annual report.
I know that, Judge.
Okay. So, and then you need to do that every year, because if you don't do that, then the same thing is going to happen again.
Right.
And so I'm going to give you 30 days to file that oath of office. And if you've done that by the 30th day, then you won't need to come back to court. But if you haven't, then you're going to have to come back to court and explain why you haven't done that.
Okay, I'm going to do that today because I'm in court now. I'm in the
courthouse now.
Yeah.
Okay. Yes, you can. It's called Oath of Office of Guardian of the Person.
Mm-hmm.
You can fill it out and you can go ahead and file. Your offices are actually physically open right here. But yeah, you can go to the clerk's office, the probate clerk's office. They're very helpful there.
Okay.
Okay.
Okay. Can I ask you one question,
yes.
Judge? How can I get a state representative to represent Osiris?
So I don't know how to answer that question for you specifically. I don't even know exactly what it is that you're looking for.
Well, the thing is, Osiris been shipped around from facility to facility, and every time I try to get some kind of legal help, you know, to try to get him placed in the proper placement, I run into a brick wall because they want all these papers. I sent them everything I have, you know, from his foster mom, from the time he was 1 year old to now. And I can't get him in the proper place because he has to be a dual diagnosed, you know, which he is a dual diagnosed, but I guess in Florida, where he was raised up at, they didn't really specify what his mental state was. So when he went to
I will tell you this, I don't know the answer to your very challenging question.
Okay.
So what I am going to do is I'm going to see if there are some resources that might be available to you that can be sent to you.
Okay.
To see if they might be places that you might contact, and with the power of guardianship, they should be free to talk to you, and then they may either be able to help you or they may be able to help you find the right place, someone who can help you. Okay.
Okay.
So I will do that. So I also, when you go to the clerk's office, make sure that your current contact information is correct.
Okay.
So that any notices or information that we can send to you? And do you have an email address or no?
Yes, I do.
Okay. So also make sure that that's part of the court record so that we can send you information and document, you know, maybe some helpful resources. Okay.
Okay, thank you.
All right. I'm going to make a note of it to see if I can have somebody send you some information that might be helpful.
Okay.
All right. I wish you well. You'll get a copy of the reinstated letters of office. And it's mental health issues, right?
Yeah, and I mean, he got some kind of learning disability too, but I don't know.
Okay. I'll see what we can send your direction, all right?
All right, thank you.
All right, have a nice day.
You too.
Okay.
What do I do?
Out of files. I know Ms. Scher and Mr. Pohl, you know, you have a matter, but my clerk. That's okay. I took these from you. All right, this is the estate of John Fox.
Yes, Judge, I'm here.
Miss Lovett?
Yes.
Okay, so I did take some time to review this file. Let me just read my notes here. So you are the current guardian of the person of John Fox, is that right?
Yes.
Okay. All right, so there were a couple of things. First of all, I received a letter from you. You can't communicate with me directly. If there's something that you're asking the court to do, you need to file a motion and send notice to any interested person so that, and then it would be filed in the court file.
Which I did. I did.
A letter.
Just the letter wasn't filed with the court. That was the only thing, but the motion's been filed back in March.
So I don't see this as filed. I can't read it. It's a communication with me directly that's improper. Okay. As far as a motion, well, first of all, I think there's some indication that I want you to know that your original letters of office had some limitations on it. You did not have the authority to make residential placement for Mr. Fox. So to make a residential placement, you were required to come back to court, file a motion, and explain to the court what the circumstances were that would authorize you to make a residential placement. So I just want to bring that to your attention.
Okay.
And then the concerning thing about the motion that you filed in March is that there was no notice to any of the interested people. So there are a number of siblings, I believe, that are entitled to notice.
Yes, they have been notified now.
Okay.
I made out nude papers and sent them all notice. They should be here.
All right, so on the notice of motion that was filed with the court, none of those people are listed. So you would have to specifically say who you sent notice to and at what address and when you did it, so that I was certain that I could hear the motion, that everybody who was entitled to be present was given proper notice.
So all the people were listed. It just wasn't on the motion. It was on the other paper. But I did file a new motion and I listed it on that. It was attached.
Okay, when did you file a new motion?
Frances, maybe you can help us out here. She was involved.
Okay, I don't see it.
I sent it to Frances. Go ahead.
Yes.
Good morning, Your Honor. This was one of the documents that I sent to the CC 201 email previously. There was an updated notice of motion, oath of office, and petition that I sent.
Oh, I wonder if it didn't get filed.
I can re-forward the email if you'd like.
So it may have come to the CC21, but I don't know that it was filed with the court. That wouldn't, it's not the same thing as filing something.
Right, I was trying to e-file it, Judge, but it wouldn't take my case number. And I had already filed a motion and the petition for appointment of guardian for a disabled person. I had already filed those two things back in March. And I have it right here in front of me, and it does list the siblings on that petition. I was not told it needed to be on the motion. I came in person and filed the original one in March, and they didn't tell me I had to list all the people on the motion, just on the petition.
So I don't, when you say on the motion, so there's the motion, that doesn't list anybody. Then there is a document called a notice of motion. And it's the document that goes into the court file that's proof that anyone who was supposed to be given notice was given notice. And that notice of motion, there's a portion at the top that says to, and that's where you list all of the people that it was sent to and all of their addresses. And sometimes if it's a number of people, then you do an attachment that lists all of those people. So,
right. Well, that was done. It just wasn't e-filed.
Okay, so they were all given, you had mailed them copies of your motion and also of, and then you filled out an affidavit saying that when you sent it and where you sent it to all of them?
Filled out an affidavit.
At the bottom, there's a statement saying that you swear that you mailed it to all of those people on a certain date.
Yes, I'm sure I did everything I was supposed to do. I was in contact with Frances, and she was helping me, and I believe we did everything we were supposed to do.
So,
and I've been in contact with all of my siblings, and they all got it.
Okay, so let me explain why this is important. It's important because down the road, when we come back and look through the court file, we have to have these documents in the court file. So I'm not doubting for a minute, Ms. Levitt, that what you're telling me is true, but the court record is an important part of this process. And if I make an appointment and then down the road, somebody says, well, I was never given notice, and we look at the court file and the proof that those things were done is not in the court file, then everything can be unraveled, right? And so we don't want to do that. We want to make sure that everybody who's entitled to notice of the motion, that the motion is properly filed, that everyone who's entitled to notice is given notice, that it's all in the court record. Then I can have the hearing, make a determination of whether or not it's appropriate, and then go forward from there. So
my sisters are contesting the notice that I wanted to be the guardian of the estate. Both my sisters are contesting.
And that's one of the reasons my concern is heightened here, because I know there is some dispute among the family members just from what I can tell from this file. And I'm also concerned because, as I said, the original letters of office in regard to the person have a specific provision that say there's no authority for residential placement without the court's review. So I can't go forward on this motion today because it's not in the proper court file. I don't have proof that all of these parties who you are even representing are objecting have been given proper notice. But what I can do is I can set it for a hearing date, and then we can clarify exactly what that process is going to be. So on the next date, we can have that hearing. Okay.
Okay, so do I need to file it with the court? Do I need to send out all those notices again?
Yes, so the petition needs to be filed with the court, and then you have to prepare a notice of motion that says the specific date it's going to be heard and the time and where and what the motion is. And then you list all of the people that are being, that the notice is being sent to and what their addresses are. And then at the bottom of the notice of motion, you're going to sign an affidavit. It's a statement saying on a specific day, you know, June 17th or whenever it is, I put proper postage on and I mailed notice to all of these people, giving them notice of the court date so that if they're not here on the next court date, I've got proof in the court file that they were given proper notice and they didn't appear.
Okay.
Okay. So I'm going to set this for hearing on July 22nd at 9:00 a.m. here in courtroom 201. That's going to be by Zoom. And you're going to have filed your motion and also the notice of motion that's fully completed. And then you're going to send it to everybody, okay?
Okay.
All right. And then I'll put in order just continuing it that day for proper notice and filing of motion.
So now that he's moved out of his nursing home into an apartment, what do I do with the court? What do I need to do?
So a motion should have been filed in advance of that move, but certainly at this point you would want to report to the court that a change had taken place and what the basis, you know, what the circumstances were about what that change were, so that the court can review it and say, okay, that's an appropriate change, and then it can be authorized by the court. So it's a motion to basically authorize what's already been done. So but you're going to want to explain what happened and why it happened.
Okay.
And ask for the court's approval of what has taken place.
Okay.
Okay.
I can come to the courthouse today and do all this. So that's what I'll do.
Okay. Thank you very much, Ms. Levitt. Nice to see you. Have a nice day.
Thank you.
Okay, so we have the Blaisdell matter. Is there any other matters that have not been called? This one. Rosemary Lamb. Is anybody here on the estate of Rosemary Lamb?
Good morning, Your Honor. Chris Fowler here for the estate.
Good morning. And why are we here today?
Judge, this is up for status. I did speak with John Malavitas, who is the attorney representing Sheila Lamb. He had an emergency that he had to deal with, so he wasn't going to be able to attend. What we've done is Mr. Malavitas' client filed a challenge to the will, which we have responded to. We also have issued written discovery to Mr. Malavitas' client. He has received answers back, but he hasn't put them in a form to transmit to me, so I'm just waiting for that. He said he can get that done within 30 days, which I'm agreeable with. And then I don't know if we want to set it for further status out beyond that, or if we want to just set a 218 order. I guess the only concern I'd have is, since John's not here and I don't have his calendar, I don't know what he has coming up. But.
All right, so let it set it for a status of discovery and to set hearing date.
Okay.
July 16.
You said July 16, Your Honor?
Does that work for you?
That should be fine.
Okay, so I'm going to ask you to prepare that order and to submit it by email to cc201@lakecountyil.gov. And for today's orders, to the attention of Kathy, Kathy.
And what time on the 16th, Your Honor? Still 10:30?
9 o'clock.
Okay. Thank you.
Thank you. Oh, Ms. Bryceland, what case are you on, Ms. Bryceland?
The estate of Anthony Gottenbeck, Your Honor. It was for the status of the GAL report. I did file an interim GAL report yesterday. This is an unusual case. We have a very high functioning ward in terms of intellect, but has behavioral issues, which is why he has a limited guardianship. I think
I'm sorry, it sounds like you're underwater. I'm having a really hard time understanding you.
let me see if this helps. Is this any better?
Not much. Let me just read what the last order says. See, was continued for limited guardians annual report, guardian ad litem's report, and hearing as necessary. No one appeared on the last date. So what's the status of the guardian ad litem's report?
An interim report. This actually is supposed to be on a change of schedule for the GAL report.
I'm sorry, I can't.
Okay. I don't know why you're not hearing me.
I can hear you. It's just very garbled. I'm going to ask you to maybe you want to send a chat with the clerk and just explain what you're asking for today or what the status is today. Okay. Can you chat with her? Thank you. Okay. Does that address everyone that is not associated with the now? Lydia, I see.
Yeah, for some reason I can't show you my face, but I'm here.
In regard to the Blaisdell case. Okay.
Yes.
Good morning, Your Honor.
Good morning, Your Honor.
And Rhiannon Little, present on behalf of Lydia Quissian, and the name Lydia on there is our client.
Marjorie,
Good morning, Your Honor.
Marjorie Shear on behalf of Robert Blaisdell. Robert is unable to connect this morning and has said that we could proceed without him.
Okay. So before we proceed to hearing, I'm assuming everybody wants to proceed to hearing. Is that right?
Yes, Your Honor, we're ready.
Okay. I just want to have a brief pre-trial with the attorneys before we proceed to hearing, before we do that, okay? So I'm going to take you into a breakout room with me.
Okay, could I have a question?
Yes.
This case has been going on for 14 years and nothing against Joe or Marjorie, but they really don't understand the total case. I mean,
okay, so I'm gonna stop you there.
Okay.
I'm gonna talk to the attorneys for a couple minutes about this case. I have reviewed it pretty thoroughly and I know how long it's been going on, and I think that would be in everyone's best interest to bring it to a conclusion. But at this point, I'm gonna talk to the attorneys for a minute and we'll come back, okay?
Okay, all right, thank you.
Who is it? Oh, you're kidding. Oh, shoot.
Gotta be fucking kidding me. Oh. Et dehors? Ils sont partis faire des conneries, so je sais pas, je dois attendre. Oh, I'm sure. Huh? Oh, yeah, okay. Who's thinking in phone? I don't know.
Your Honor, my client's calling in right now. Although you're muted.
What did we find out on? Oh, here. Join with video. I hate to sound dumb, but why is
Am I not hearing anything or is everybody just quiet? I'm sorry.
Lydia, there's nothing, everyone's muted. We're waiting for something right now.
Oh, okay.
So apparently, I didn't realize my client needed the meeting ID and the password in order to call in. So we're just giving that. We emailed that to him. So he's going to be doing that. I apologize. Kind of new to this whole Zoom thing.
No, we all are.
The case be continued to 2/14/2021 at 10:30 for status on the guardianship and GAL report.
Okay, so if she wants to prepare a proposed order and submit it, then I can review it, but she should add, just tell her, I'll tell her. Okay, so I'm going to speaking to Miss Bryceland now, not on the Blaisdell case. So Miss Bryceland, I know that you've been corresponding with the clerk, and it's my understanding that you're asking as guardian ad litem that the matter be continued. Can you hear me? You're muted. Oh, there you go.
Yeah. Okay.
So you can hear me now, right?
Yes.
I would just ask if you prepare an order stating what the current status is, and then request, and then proposing the continuance date that you had suggested, February of 2021, and then you could submit that to the clerk, and I can review it, and if everything's appropriate, I would enter the order.
Okay.
Okay.
For the order to the clerk, it's CC 201 Kathy at.
Oh, no. I'll give it to you again. I'll give it to you again. Okay. CC 201 at, this is all one word without interruption, Lake County il.gov. And then just in the subject line, you would put it to the attention of Kathy with a K.
Okay, great.
Kathy's not in.
I'll do it right now.
Okay. Terrific. Thank you so much.
Thank you, Anna.
Okay, so now I'm recalling the Blaisdell case, and I think we have everyone here. I'm glad, Robert, that you could join us, and Lydia was here previously, and I'll just tell you what's happened this morning. I spoke to the attorneys in a private conference called a pretrial conference, and I know it's always a little bit unnerving when there's conversation being had about your case and you're not a part of it, but sometimes I think it's important because it helps me to assess what's going on and to make some candid recommendations to see if we can get this matter resolved. So I want to start by telling you that you are both very well represented, and your attorneys have not just today, but every time that we have been in court, have advocated very and passionately for your respective positions. I will also tell you that although I have not been involved in this case since the beginning, I do have involvement in the recent past, and I did take some time in anticipation of today's date to go back and look through the file. And although you two are the only two that have lived through it in its entirety, I can see what a lengthy and challenging, difficult situation this has been and been going on for a very long time. And if we don't bring it to its conclusion, I can see that it could go on very long into the future. And there are costs that are associated with having something like this go on for a long time into the future. They are both emotional and they are financial. In this case, we are now have a situation where we're talking about arrearages, and I am very well familiar with both arguments on both sides. As I said, they have been very well articulated by your attorneys respectively and have been very passionately argued. And I will tell you candidly, there are challenges to both of your positions. There is not one side or the other that is going to get a you win celebration victory and walk out of the courthouse with a big win. I don't see that happening. I see you spending a lot more time and a lot more money and a lot more frustration. And I think no one will be best served by. I think that the very best thing that the parties can do is bring this matter to a conclusion, which can be done by a settlement in dollars that nobody is going to feel particularly thrilled about, but is going to be a big win for everyone because, first of all, a judgment for dollars and then trying to collect those dollars for years into the future is expensive and time consuming and is not dollars in hand. And on the other side of it, although I know, Robert, that you feel that these are dollars that you don't owe, you're at risk that you will owe them or even potentially more. It's the only way to bring this thing to its true conclusion. So I am going to make this recommendation for settlement, and it's this, that Robert would pay to Lydia a one-time lump settlement in the amount of $19,000 with credits given for the $700 a month payments that have been made, any payments that have been made from any source, either a garnishment or a voluntary payment or whatever, since that last March court date to current, and that this matter would be resolved. I think it is the thing to do. I will tell you this, sometimes people will say, why didn't somebody let me know what a long and treacherous and expensive and wasteful path this litigation was going to be? I'm telling you that now. I think that it's time to bring this matter to its conclusion, and that would be to the benefit of everyone. Not to mention, how many children do these folks have?
We have 2 girls.
2 girls. And I can tell you that they continue to ride the waves of this litigation right along with you. I would bet this family is not well served by this continuing on forever into the future. So I am going to strongly encourage you to speak to your attorneys, have a candid, frank conversation with them. But I am going to recommend to you that we bring this matter to its conclusion as soon as time as possible. So having made those recommendations, if there's anything I missed, I'll ask the attorneys.
Yeah, Your Honor.
Actually, Lydia, I'm not actually asking to hear from you because I don't really want to hear argument from you. I'm not going to hear from Robert, and I'm not going to hear from either side, because if we're going to have a hearing, that's when I hear testimony. Okay.
Yeah,
I will.
Your Honor.
Oh,
I apologize. This is Joseph Paul. we hear your settlement recommendation, and can we talk privately with our client?
Yes. Would you like me to put you in a breakout room?
Yes, could you?
Yes, please, Your Honor.
I just need Robert to mute himself, to unmute himself if we go into a breakout room.
Okay.
I don't know if he knows how to do that. Does anybody know how to do that?
On a phone?
Yeah, there's like a special number that you push, or I guess I could Google it. I'll Google it. It's fine.
I'm sorry, I don't know.
I think the judge might be able to unmute him, Marjorie.
I can't. No, I can't.
Okay.
Another option is we simply call our respective clients from our cell phones.
Well, if you want to do that, it's up to you. If you want to do that, we can come back in 20 minutes or 11:30 maybe. You want to do that?
That might make the most sense. We could overcome our technical problems here.
We could do that. I just need to leave promptly at noon because I'm running the family law meeting today.
I don't think that'll be a problem. Do you want to come back in at 11:30?
All right,
Yes,
that sounds perfect. Thank
Okay,
you.
great.
Lydia, if you can hear us, leave the
Yeah.
meeting and we'll call you.
Okay, so leave the meeting.